When we started this module, one of the key points we made was that Australia is a common law system, as distinguished from other legal systems around the world, most of which are civil law systems. Now, civil law systems are based upon codes or written laws, statutes, acts, etc. And generally, they are made by some legislative body, a body that writes those particular acts. We have that in Australia, Parliament, and we've just been through how our Parliament or the legislature makes laws, specifically acts or statutes. And we also covered how sometimes it can delegate aspects of lawmaking to the executive, particularly when it requires technical knowledge or details around the implementation of a specific law. But a distinguishing feature of a common law system such as that we have in Australia is the role of judge-made law. So that is, judges can actually make law. How do they do that? Well, they do it through something called the doctrine of precedent, which is what we're going to spend a little bit of time just to get an understanding of so that we can appreciate the legal system overall. So in a common law system, the decisions of most courts are recorded and published, which leads to the development of case law. Case law comes into play via the operation of the doctrine of precedent. It's not that any court can make whatever rule it wants. In fact, there's a strict approach under the doctrine of precedent. What the doctrine of precedent says, that if a court has before it a case of similar facts, then that court is obliged or must follow the earlier decisions of other courts higher up within the same hierarchy. That means there isn't a freedom within the court to decide what it wants. It must decide the same way using the same logic that courts higher up in the system do. As a result of the doctrine of precedent, we have some sense of certainty. We know how cases are going to be decided because those lower courts must follow the rules that the higher courts set. We also have a sense of fairness and justice because similar decisions are going to be resolved in similar ways, and those cases are published so we can access the law. So despite the fact that it may sound quite arbitrary with judges making law, the doctrine of precedent starts to mould it towards those criteria associated with good law. Now, to appreciate the doctrine of precedent, we do have to look at some specific terminology. So when a judge makes a decision, that's called a precedent, and it's an extension of the normal use of that word in English. But when are precedents, or when are these decisions binding? Well, what we have is court hierarchies. You may be aware of that there are some courts that are considered higher than others in our legal system. So a judge is only bound to follow the precedents of higher courts in the same hierarchy. So imagine that we have Judge 1, Judge 2, and Judge 3. Judge 1 must follow the decisions of what Judge 2 and Judge 3 say. Judge 2 has to follow the decisions of what Judge 3 says, but not Judge 1. And Judge 3, well, they can actually change their mind under this system, which allows this law to be flexible. And right there really is the principle of the doctrine of precedent. What we have is that judges in lower courts must follow the legal reasoning for similar cases of judges higher in the hierarchy. That means judges lower down, like in the magistrates' court, actually can't create binding precedent because there's no one lower in the hierarchy. Now, we also have another word, persuasive. So when a judge issues a decision, that can be considered persuasive but not binding. So that means lawyers will bring it up in an argument and the judge will listen to it, maybe put a fair bit of weight into it because a judge has thought about that issue, but they don't have to decide their case exactly the same way. That's in contrast to binding precedent. If they're lower in the hierarchy, they have to decide it the same way. So the second major thing then to think about is we have precedents, we have binding and persuasive precedents. By the way, those persuasive precedents may come from a different court hierarchy. What does that mean? There's a different hierarchy in New South Wales, for instance, compared to Queensland, because there's a different state government. So the Queensland courts are not in the New South Wales hierarchy. That means any decision in the New South Wales court, even from their Supreme Court, their highest, is not binding on a lower court in Queensland. But it would be persuasive, right? It would be something that the judges would look at and it might persuade them. So in addition to binding and persuasive judgments, what we find is that judges, when they make a judgment, actually are saying two things. They say things which are core to the reasoning for the decision, which we would call the ratio decidendi, the reason for the decision. That is what's binding. We made this decision for this reason. That becomes binding. However, often they will say things that aren't directly relevant to the case. When they do that, it's called obiter dictum, and that is not binding. So even within the judgment that you get, you have to be able to discern what is a reason for the decision, as it's only the ratio that is binding on the lower court. So if we simplify this all down, where are we? Courts must be within the same hierarchy for something to be binding. So Queensland courts bind Queensland courts. New South Wales courts bind New South Wales. Victorian courts bind Victorian courts, etc. So you've got to be in the same hierarchy for things to be binding. Higher courts bind lower courts. So the Supreme Court binds the District Court, which binds the Magistrates Court, but not vice versa. Higher courts bind lower courts. Now, within this hierarchy, even within one of these courts, like the Supreme Court, there's actually multiple classifications or divisions that we can talk about. The main one we want to look at is this idea of the full court and the court at first instance. So sometimes an issue goes straight to the Supreme Court. It's a very major legal issue, and it will go straight to the Supreme Court. If that happens, it will be heard by a single judge at first instance. But then we also know that we need to have an appeal process. So what happens with an appeal? Just say you lose that case, you can appeal to the full court of the Supreme Court. You're in a court of the same name, and your case gets heard twice, once at first instance and once by the full court. So what happens for the doctrine of precedent there? A single judge, so this judge at first instance, is not bound to follow the decision of a single judge of the same court. Why? Because they're on the same level. But they are bound to follow the full court. So this is the highest court, if you think about it, in terms of the state-based hierarchy. We'll come to the High Court itself a bit later to clarify that. I was just talking here about the Queensland-specific hierarchy. The full court binds single judges. Single judges do not bind each other because they're on the same level. And here we have a representation of the court hierarchy system within Australia. You can see that there are all these state-based systems. We're going to concentrate on the Queensland system. You'll also remember that we know which matters get heard in which court system based upon our constitution. So that means, in fact, we have two court systems that are unified by the High Court. So if it's a federal matter, it will go into the Federal Court of Australia. Now, because family issues are so specialised, we do have specific courts which tend to deal with them. But we have the Federal court, original jurisdiction, so just say you had an IP issue, it would probably go to the federal court. If you weren't happy with the result, you lost, you could appeal to the appellate jurisdiction. That's what I was talking about before, how you have a single judge and on appeal you'll have multiple judges hearing the case. In Queensland, we have the Magistrates Court, the District Court and the Supreme Court. Both the Supreme and the District Court have original jurisdictions and appellate jurisdictions where, for instance, we have multiple judges sitting in the appeal division. Just to reiterate the doctrine of precedent, if you're higher in the court system, you bind those lower in the court system, but you are only bound by those in the same hierarchy. So other states and territories are not binding. They are in fact persuasive on, for instance, the Queensland judges. You'll notice in the middle here we have the High Court of Australia. This is the way that we unify the legal system with judge-made law in Australia. Our ultimate court is called the High Court of Australia, the appellate jurisdiction. It does hear a very limited number of cases in original jurisdiction, so you can sometimes go to the High Court at first instance, the first time you have a case. That's generally going to be a constitutional issue, because constitutional is between the states and the federal government. So where does it go, right? You're going, where's the question? It really shouldn't go to the state because it's about all the states and the federal. So it goes to the High Court. It's so important. Second, not everyone gets a chance to appeal to the High Court. While it's on the top there, they actually have to agree to hear the case first. So you do something called you seek leave to appeal. So you actually have to ask them whether or not they will hear your case. And so the High Court decides whether or not it will hear your case and gives reasons as to why they want to hear it or not hear it. It tries to take on cases that will impact the entire system within Australia. And in so doing, all the other courts are bound to follow its reasoning because it is the highest court in the country, and therefore it provides a unification of our system and rules as applied by the judges. Of course, the full court of the High Court is not bound to follow its own decisions, which allows some flexibility if the full court of the High Court decides to change its mind on a legal principle. Wow, all those courts. Well, how do you decide where you're going to take your case? That's called jurisdiction, and I've been hinting at it all the way through. One way is we have to decide which government is responsible for that area of law. The responsibilities of government are set out in our Constitution. So we're going to have some things that go to the federal system, some things to the Queensland system. Furthermore, the key principle is that the most important cases or the most difficult cases, the most impactful cases, get heard by the most experienced judges. So that means we need some way to differentiate between what are the harder cases and what are the easier or less impactful cases. And so we have a number of benchmarks that decide where matters are heard. So for instance, if you have a contract dispute that's worth more than $750,000, that's a lot of money, it's going to go to the Supreme Court. If it's between $150,000 and $750,000, goes to the District Court. Under $150,000 are more minor, even though it's a lot of money, are more minor though in terms of business issue, goes to the Magistrate Court. The same for criminal issues. Depending upon how serious the crime, you will potentially end up in a different court. Now, our aim here isn't for you to memorise these levels, etc. The only reason we provide these is so that you can apply the doctrine of precedent. For instance, I should be able to tell you, there's a contract dispute and there's probably damages of $500,000. Which court is it going to go to? So really, this table is a simplification and it allows us to be able to quiz you to see if you understand the principles of things like jurisdiction, doctrine of precedent, etc., which are all necessary to understand how the Australian legal system works and, importantly, how it will impact your business. And you can see here we have a similar outline for the federal court system. Again, no need to memorise it. Anything we do is open book. We don't directly test this, but we will go through it in shoots with some examples, etc., just to be sure you understand the principles behind our legal system. One of the things I mentioned earlier was that the doctrine of precedent does allow our system to be flexible as well as being certain, accessible and fair in terms of treating similar cases similar ways. How is it flexible? Well, courts at the same level can actually change their opinion if they think that there's an error made or if things change. And I think one of the most striking examples of that is around Indigenous land rights. Early on, courts had a view that Indigenous peoples only had limited systems of governance and law, and that translated into an approach or a doctrine called terra nullius, which in essence treated Australia as uninhabited. Now, that was clearly wrong. We weren't, and Indigenous peoples had some very advanced systems of governance and laws that were either difficult to appreciate from the British perspective or were just ignored out of self-interest. I should note for completeness that not all legal opinion was built around terra nullius, but it was probably the prevailing way it's been explained to date. The current view in the Australian legal system was only clarified relatively recently in terms of our history and in terms of legal development, when the High Court found that native title was valid. It was based on a common law principle that Indigenous law remains in place wherever possible when it hasn't been extinguished by subsequent legal actions or decisions, such as granting land titles. So what we see here is a major shift in the view under common law of Indigenous land rights. And it's a result of judge-made law where the judges at the same level are able to change their opinion. A similar example you can see occurring in the commercial setting where Section 51 of the Constitution says that the federal parliament has the power to make laws for foreign corporations and trading or financial corporations. Now, originally, when the High Court first held that, they said a trading corporation would exclude mining companies, manufacturing companies, religious, charitable, scientific, literary companies, printing companies in local areas, etc. There were a whole lot of companies that they didn't consider trading companies. Now, this was super important for business because, remember, the Constitution says whether the federal government or the state government has power to make laws. So it would say, look, all the banking companies are regulated by the federal government, but all the manufacturing companies are regulated by the state government. You know, what happens if you got a little bit of both? It becomes very messy. So over time, as we get more and more national commerce and companies across borders, it becomes increasingly clear that splitting the power this way is causing all kinds of problems. So the High Court substantially changed its understanding or the definition of a trading corporation. A trading corporation now is any corporation whose trading activities form a significant or substantial part of its overall activities. So it basically means, do you have turnover? If you have a reasonable amount of turnover, you're a trading corporation. That is essentially all commercial companies. So again, we see that judges being able to make law allows law to change and evolve as circumstances change and as our understanding of issues change. Albeit, maybe slowly, but our legal system does respond in that way to the changing situation before it. A key strength of the common law system. Okay, That's enough about our doctrine of precedent and how judge-made law works. The reality is, though, that most of our law these days is made by parliaments. So why this emphasis on judge-made law? Well, because the way law works is it's not as clear-cut as though there's just a statute. And judge-made law becomes important in how those statutes are applied, something for our next video.